All right, ladies and gentlemen, those of you who wish to watch or listen to the legal panel, if you could retake your seats, because we've effectively, split the crowd in two. You might like to centre up a bit more so that everybody can see our distinguished panel. But if we could just all take our seats now, and let me introduce to you the legal panel. And it's being chaired by Palmerston North lawyer and outspoken, shall we say, right-leaning columnist for various publications, Liam Heir, along with the former Attorney General, David Parker, and retired District Court Judge, David Harvey. So, Liam, you are the chair. I will let you introduce the topics that you would like to bring up, and then after these eminent gentlemen have talked amongst themselves for a little bit, there will be an opportunity for you guys to ask some questions as well. So, Liam, I'll leave it with you.
All right, well, thank you, everyone. So as Peter said, my name is Liam Heir. I'm really the odd one out of this panel because we've got two very distinguished panellists, a former judge who's a well-known scholar of the law, and in particular technology in the law and how they interface, and a former and maybe future Attorney General. And then yesterday, I'm really pleased to say that I acted in the purchase of a dairy in Fielding. So there's a... And I have to say, we were very successful. We got that one over the line. People like me, we always have an inferiority complex around people like this, people who are real lawyers. I'm a commercial lawyer. I've been to court 5 times. I've got a 100% track record of winning applications I've filed. But I have to say, 100% of those have been moving the admission to the bar of family members and people I've mentored. So there wasn't too much risk of failure at that point. With these very learned and important guests, I think there are a number of things we can cover in terms of the law and freedom of speech and where it is in this country. Obviously, social media and the regulation of social media is always a perennial topic. And, in view of the elections in the United States, it'd be a really interesting one. And I know David Parker has some good insights into that, or some good, wants to provoke us with some opinions on that. I want to talk about the gang patch ban, which is on the books now. And then I want to talk a little bit about my own thought, my hobby horse at the moment, which is the way that the broken civil justice process, the broken legal system, exacerbates the stress on ordinary people who get caught up when they've said something wrong or they're in trouble for something that they've said. So I think, David, you're really keen to talk about social media, so why don't you get us started with a nice provocative speech.
Thank you, and thanks for the invitation to be here. Can I say I agreed with a comment that was made by the chair of the last session that freedom of expression for me is not a left-right issue. You can go back in history and find powerful individuals and governments, right and left, suppressing the opinions of the others. And I abhor that and am a believer in the importance of free speech. I thought I'd talk a little bit about what worries me about the where we've got ourselves into a bit of a pickle in the Western world when it comes to extreme content on social media. On the 15th of March 2019, an Australian person with very strongly held views on immigration advertised on the internet his intention to shoot people, then murdered 51 people in a mosque in Christchurch and posted it online together with his political viewpoint in order to promote his hateful views. The access to the footage which was on 8chan and various other places that it had been copied onto, was blocked by internet service providers in New Zealand for a week. After the week passed, the internet service providers voluntarily allowed access to anyone in New Zealand to that site. I thought that was a bit unusual because I would have thought that most people would agree that rights to freedom of expression don't extend that far. And so I phoned up the chief executive of one of the largest internet service providers in New Zealand, who I know quite well and I respect him. And I said, why are you doing this? And he said, it's not for me to censor. I have no liability for content, and I will suffer competitive disadvantage, or may suffer, and I don't really want to put words in his mouth, so I might be going a bit far with that. In any event, essentially said, we're going to let it rip. I think there's a limit to freedom of expression when it comes to harming other people. And I don't mean through expression of extreme opinion or causing offence. I don't mean that. But snuff movies, filming live sexual abuse of children and sharing it on the internet. Beg your pardon? Political manifestos. I see a difference there. So I personally think there is an issue as to what is it that the Western world should do about that. Now, the response of the illiberal world is to censor, including things that ought not to be censored, and to, on occasions, torture and imprison the people who express an alternative viewpoint. So we shouldn't look at that for a model. I personally don't like the idea that governments should regulate this space. I think it's too hard to get the regulatory line right. And my sense is that the mistake that has been made is that the law is stultified by the complete exclusion of liability that was afforded to internet service providers at the time, when they were essentially a bit like a postal service. The postal service has no liability for what's in the envelope, and on that basis, at the time when you were sending emails to each other and I was on extra.co.nz, the complete exclusion of liability was agreed. So I posit to you that if we don't get this under control in the Western world, we will actually have a regulatory outcome. And I'll give you the most recent example of that, which is in Brazil, which is not the least free of countries, where Elon Musk was threatened being closed down X as a platform, and yielded to the Brazilian government their censorship of certain accounts, including political accounts that were from Bolsonaro supporters critical of the current regime. And I think that's the risk, that if we don't have some other mechanism like allowing the courts to find this balance between freedom of expression and a duty not to sell a harmful product, we'll end up in a bad place.
Yeah, so I think that, you said you were going to be provocative, but you've given a very nuanced, careful, and I think pretty intelligent answer there, or idea there. So what you're talking about is that if we're not careful, if we don't have mechanisms in place to resolve things peacefully and at their appropriate stage, we might end up with a more extreme regime down the end, because people will just be fed up with it, right? Is that a sort of fair?
Yeah, I think you leave the route open for governments to intervene, because most people, I know there's someone there shaking their head, don't agree with me, but I think most people in New Zealand would not think it was right that the terrorists' live streaming of video murdering of 50 people was enabled.
So can I just say, I'm a conveyancer, so I don't actually know how to talk to a judge. Even a retired one? Do I call you judge? Do I call you sir still?
Your Honour. Your
Honour?
I've got a name.
Yeah, okay. Yes, but there's too many Davids. This is like the Labour Party circa 2014. Everyone's called David.
And I'm on the left-hand side of the stage.
Well, Your Honour, I was wondering if you... David is good. All right, David number 2. I was wondering if you could speak to that, and also, if you wouldn't mind, because I have read some of your articles and things like that, to talk about maybe, where that harm threshold, does start to justify action, what the sort of tests for that might be, and actually having a workable law that's not too overbroad and doesn't infringe on freedom.
Okay. First point, I agree entirely with David, and I never thought I would, with the fact that it's not going to be possible to regulate the internet. As far as the Tarrant live stream is concerned from March of 2019, very, very quickly, and within a matter of days, the then chief censor had declared that that particular content was objectionable. It was therefore unlawful to possess a copy of it. It was unlawful to distribute it. And if the internet service provider said, we're not going to be censors, then they might like to take some legal advice, because they were finding, they would have found themselves in some considerable difficulty. Now, that raises another issue. Is there a safe harbour that is provided for platforms like Google and Facebook and Twitter and internet service providers and so on and so forth? And the answer to that is yes, there is. Safe harbour is a concept that, and David referred to it, the liability of the post office for the content that's inside the envelope. They don't have any liability for that. The safe harbour provisions of the Harmful Digital Communications Act 2015 provide circumstances where platforms will not be liable for transmission of content unless certain circumstances are fulfilled. And once those circumstances are fulfilled, then those platforms do become liable for distributing content. Now, I've mentioned the Harmful Digital Communications Act, and that is a piece of legislation that deals with communication of electronic content. It may be harmful. Why may it be harmful? If it fulfills the definition that is contained in the legislation, which is that it causes serious emotional distress. And there are two pathways that an individual has under the Harmful Digital Communications Act. The first pathway is to get the content removed or something of that nature, which is possible under by going to court in the civil jurisdiction of the district court after certain conditions have been fulfilled. If the person who is making the post intends to cause serious emotional distress, then they have committed an offence for which they may be prosecuted. So in that particular respect, there are remedies that are available. Now, somebody back there is shaking their head, and I know exactly why, because this is all about freedom of expression, and you're absolutely right. Because in Section 6 of the Harmful Digital Communications Act, subsection 2 states that in dealing with matters under the Harmful Digital Communications Act, judges have to take into account the provisions of the New Zealand Bill of Rights Act 1990, particularly Section 14, which relates to freedom of expression. So you've got that sort of hurdle that has to be surmounted. Does this particular communication mean that we can put to one side the guarantees of freedom of expression under Section 14? Is this a reasonable limitation on the freedom of expression that allows this particular prosecution or this removal of content to go ahead? And that is an area in some respects where there has been some regulation of internet content, and it has been quite successful, but it only is available for individuals and it isn't available for groups. So when you consider that you've got the Harmful Digital Communications Act on one hand, and you've got the Films, Videos and Publications Classification Act, which involves the classification of objectionable content, which is what happened with Tarrant's video, you have some ways of keeping a balance involved that does involve the state, and probably about as far as it can go, with the way in which freedom of expression may be limited.
Yeah, well, I disagree on that last point, because I think the law has been stultified and is unable to move by the very extreme exclusion of liability that we have. Effectively, it's an exclusion of liability even if harm has been caused. The increase in teen suicide rates is worrying to us all, I think. The Australia announcement yesterday is seen as a response to that. Proposals to limit the access or stop 16-year-olds having access to social media I'm not suggesting that's the right remedy, neither am I denying it could be the right remedy. I'm just saying that I think as a point of legal principle, extremism on both sides is wrong. If you don't trust governments to regulate these spaces, you have to have someone that's able to mediate the space between harm and freedom of expression. Now, if you look back in history, Pitt the Younger in the late 1700s and early 1800s was a reformer. But he didn't like what had happened in the French Revolution across the ditch, or across their ditch, and so brought in sedition laws to both stop meetings of people who might be of a similar viewpoint and the promotion of those meetings. As a consequence of that, people in the United Kingdom who weren't royalists like he was thought that was going too far, and over subsequent centuries there was, mediated through the courts, the development of the law of defamation, which developed things like justification, fair comment, qualified privilege. And I personally would like to see room to move rather than a regulated space that creates black and white lines that can't move. I would like to trust the courts to try and find a way through this dilemma.
So that's a great common law answer. So you're sort of suggesting, it's a and the tortious thing. If you cause someone harm, there's going to be, that person's got a right to seek redress against you.
Yeah, it goes back to the law of defamation. Some people in this room might not agree with it, but the law of defamation goes back to Roman times.
Yeah.
And people's lives can be ruined.
Yeah.
And therefore, there is a right to a shield against some things. So
now, I can see Jordan Williams at the back, and I'm not going to call on you yet, or ever, but I'm going to use it as an example, though, all right? Because Jordan had how long did it go, 5 years? How long were you tied up in a defamation case? Didn't lose any step of the way, but he ended up having to settle just because the civil litigation process was so completely, completely procedural, completely ruinous. I talked to the older lawyers about what it was like to be a litigator in the 60s and 70s, and they sort of rocked up to court having written nothing down, presented oral arguments, got a judgment done, and that's right. That sounds awesome, But so when we're talking about having people being able to bring their own remedies, being able to trust the courts to mediate this, how do we do that when even the laws we have on the books at the moment for things like defamation are so fundamentally broken that they're only accessible by the rich and powerful, and they very, very rarely resolve anything anyway? Like, is this one of the things where actually a lot of the issues we have are caused by the fact that the legal system, especially in that civil area, seems so broken?
I entirely agree. I have absolutely no dispute with anything that you say. The system is clumsy, it's inaccessible, it's complicated, and one of the things that I have constantly been trying to do since the inception of the internet is to use technological measures to improve access to justice. We seem to be heading that way very, very slowly, and making appearances in court by video link or something like that is one way of doing it, because it means that people don't have to take an entire day out to do a 5-minute appearance in court. If there was anything good that came out of COVID, and there wasn't a lot, it was that the courts began to develop access to court hearings using video links. And over lockdowns and so on and so forth, that became a way of accessing justice. And it was great. But the problem was that after the emergency had come to an end, we went back to the good old ways, where everybody had to rock up to court at a particular time and travel around. I can remember that there was one lawyer who thought it was absolutely brilliant that he could make an appearance in court by way of video link, because he made 4 appearances in court before lunchtime, the courts being in Pukekohe, in Papakura, in Manukau, and in Auckland, and he didn't have to leave his office. He would have only been able to make one of those appearances if it had to be by way of physical access. Now, factor in that that type of facility can be available for average citizens, and you have something that is really remarkable. But that's just one aspect of it. Complex rules, complex procedures make it extremely difficult. One of the things about, and if I go back to the Harmful Digital Communications Act, if you wanted to get material taken down, and the action is not only against the individual who posted the material, you can bring proceedings against the platforms like Facebook or Google or whatever. You have to go to the district court, which means that your case goes into the civil stream of the district court, which can take forever. Now, of course, internet time is really quite different from court time. Court time is in a world all of its own. You know, I mean, you really need a time machine to get around there. But that particular immediacy of relief that was contemplated by the Harmful Digital Communications Act is not there as a result of court processes. And really, one of the things that needs to be addressed, in my view, are court processes. Because if somebody is having some difficulty with defamatory content on the internet, harmful content on the internet, or something of that nature, the processes that are available mean it takes forever to get sorted, and that is a real problem because the harm continues all along. Stephen, did you have a comment?
I did, but I don't want to hijack. I'm just concerned that we all share a passion about the dreadful situation, the shameful situation of our legal justice. But I'm more interested. I never expected to be as full of delight as I am hearing David Parker endorsement of the need for defamation and other remedies to bad currency circulating in the market.
Well, do you have any comment?
Can I just comment on the court thing before we go back to that? I started practice when people could litigate over a car accident that was worth $1,000. We used to act for Wilson and Neil in Dunedin, in my law firm. They used to sue for the last $7 of a hire purchase contract. It kept contracts clean. The hire purchase, last payment on a hire purchase contract was still made, wasn't ignored because people knew that they wouldn't recover the last $7. Now, there are a number of reasons for that. One was there was the cross-subsidisation of court processes through the conveyancing scale, and so the litigation partners and employees weren't expected to earn much. But processes were also a lot simpler. Judgments were shorter. I mean, I have long been critical of the legal, of the judges in New Zealand writing judgments that are as long as books, and they are. You look at the length of the New Zealand law reports back in the day, and they would be one volume for a year. If you were to print them in that format these days, they would be 4 or 5 volumes. It's become ridiculous. What's the answer? I've got to the point that I think you need quotas. I think there should be a percentage of the district court civil jurisdiction no longer works, really. It's hardly used. I think you just about need quotas. I think 50% of the civil proceedings that are lodged in the district court, and it can be for the court to decide which of the 50%, should have to be set down for hearing immediately with no interlocutories. And that the judgment should have to be delivered orally at the end of the relying on it. The second thing I would do is, in respect of these remedies, they should be people's remedies. I don't think you need to create legal risk that's hundreds of thousands of dollars or millions of dollars for internet service providers or for social media doing the wrong thing. I think if you left that within the realm of the disputes tribunal and you created a people's remedy at an amount that's not going to drive the internet service provider broke, you would see a response, whether it was the use of algorithms, whether it was the social media companies coming to government and saying, we need safe harbours. I don't like the current safe harbour, it's far too broad. I would agree that if they're just publishing a very broad definition of media including people that I don't like and disagree with. I think they need a safe harbour like that, but they need people's remedy.
That's great, and I just want to apologise to all the non-practitioners of the law out here, because this is quite in the weeds sort of stuff. But really, it is important, because when we're talking about the chilling effect, that fear that shuts people down, that makes people scared to talk or voice their opinion because they might get in trouble, it's exactly the disproportionate and the delay in the response and the legal processes that's the problem. And people come to me all the time. I said I'm not a court lawyer, but one of my clients have asked me if we should go and instruct a barrister. I always say there's two ways to ruin your life. One is to lose a lawsuit, and the other is to win a lawsuit, because it's exactly the same ruinous financial outcome, the same stress in your life for years and years, and that disproportionate cost of interacting with the law has a real chilling effect. Jordan, I think you had a question?
David Parker created a question for Judge Harvey. Mr. Parker,
David's fine for me too.
you said earlier if I framed it correctly, that defending the freedom of expression risks undermining the primary cause of the freedom of speech. And it was very relevant to the Christchurch matter, because I was on the council at that stage, and it was a debate within the Free Speech Union. Are we solely about free speech, or are we about free expression? And where we got to, not by, we didn't all agree, but where we got to was the awful video that you could argue is free expression we're not going to defend, but the manifesto for which is words, absolutely offensive words, but words that could arguably assist in seeking or understanding what on earth was in this guy's mind, we did argue shouldn't have been censored in the way that the chief censor did. So I just want you perhaps comment on that. And then Judge Harvey, on the Digital Communications Act, how do you defend that truth is not a defence, and why shouldn't it be a defence even if it is offensive?
On your first point, look, I haven't read that for ages, so I haven't. I don't want to be hung, drawn, and quartered based on my opinion here. But I probably agree with you that there's a difference between the two, and that in respect of the political ideology, flawed though it is, I think people have a right to judge that. Yeah.
Okay, just to answer Jordan's question, truth is a defence in actions for defamation. So if I say something about somebody and it turns out to be true and they sue me, then I can use truth as a defence. Jordan's concern is that truth is not specifically stated as a defence under the Harmful Digital Communications Act. Under the Harassment Act, the public interest, Section 17, is available as a defence to an application for harassment. And truth is listed as a number of factors that a judge has to take into account if they're going to make a takedown order removing content from the internet. Now, the thing is that I could be facing a situation where I get the argument, but the content is true. Okay, what you have to do is look at it within the entire context and decide whether or not the truth of the statement overrides the harmful nature of the communication. Alternatively, the alternative argument, and this is where I'm being a lawyer, Jordan, I'm having a bob both ways, truth hurts. And therefore, truth can be taken into account in determining whether or not content is harmful if the truth hurts. But to say that truth is not available as a defence is not quite correct. Truth is a factor that has to be taken into account. Sorry, I'm being a lawyer.
So it's...
But the more important thing, if I can just butt in, Liam, we've been talking a lot about court proceedings. And can I put this into the context of freedom of expression, because it really is very, very important. Court proceedings are all about bringing information before a fact finder or before a decider so that an outcome or a resolution can be reached. That type of information, we call it evidence, is very, very important, and it must be a right that is preserved for everybody. And in that respect, it is a communication right, if you like. It's kind of like free speech. And the problem that we have, and that Liam has raised, is that people are being prevented because of cost, complexity, and all the rest of it from exercising that right. And I agree with David. A people's remedy situation sounds very, very good to me.
I think it's it's an excellent suggestion. But look, I mean, I think it's not just the cost and the complexity. We're dancing on the head of a pin about things, but people need to be able to apply the law to themselves, to how they make their own decisions and govern themselves in their daily life.
The law needs to be able to develop.
Yeah.
It can't at the moment.
Yeah.
Can you take three quite interesting examples we had in mind when we were debating this on the council on this issue? The little girl burned by napalm running down the road after the bombing in Vietnam was an iconic image that probably, maybe with General Key shooting a guy in the ear, the two of them changed public views toward the Vietnam War. Very important images. Maybe Hunter Biden's laptops, where in the US, despite the establishment and 3 or 4 organs of the establishment conspiring to try and suppress that, freedom of speech meant that got out. Despite everyone in authority saying it was false, which we now know was false, was untrue. Any remedy that can suppress something because it's horrible can be used by those who don't want the public upset to stay in power. And I ask really, how do you resolve that without saying at some stage there are some absolutes?
But okay.
Jordan referred to the manifesto.
Yeah.
I recently supplied that because I got it lawfully from the censor to the members of my staff for a thing that we were doing, and they thought it should have been circulated because it was sort of silly.
Yeah. Can I just say, so Stephen, you're talking about the fact that the truth does hurt, and that's why the truth needs to be out sometimes, and truth needs to always be a defence. And I tend to agree with that. And I guess, I guess the distinction that's been made in the case of a harmful digital communication is that there are sometimes there's not necessarily the same public interest in someone texting me constantly to tell me how fat I am and how I'm dressed shabbily and my ugly my beard is, despite the fact that it's true. There's not, and so there is always going to be there's always, and the problem is how do you draw the line in a way that you can predict what your behaviour is going to be and how the law is going to come down on it? I mean, I believe in erring on the side of giving a defence of truth always for that reason, but I think that David too, is that sort of where you're coming at in terms of talking about the truth hurting?
Yeah. Look, let me make one thing very, very clear. I've told you what my interpretation is of the law and what the Harmful Digital Communications Act is concerned. I am a free speech absolutist.
Well, I'm not.
Yeah. Well, you see, this is where we differ.
Well, let's hear the dissenting judgment.
Speaking from my heart, I am a free speech absolutist. I realise that there are areas where I cannot go with an absolutist approach, and because I prefer polite speech to confrontational speech, that is the way that.
So, do you think you should be able to defame me? Because that's a limitation on free speech. So
it is.
I'm posing it to you because we haven't resolved it.
Yeah, no. So I don't know the answers to these things, but I'll posit an idea on that one. It seems to me that society has, and there've been disagreements along the way, but society's largely respected institutions that are independent of the state that moderate their own cadre. It's the wrong word, cadre, but right-wing fanatics in the media. But the Press Council and the Broadcasting corporation, or broadcasting. What was the standards of the BSA? They and their equivalents around the world have acted as a moderator of those within that grouping. And maybe there's a safe harbour for them. It seems strange to me that the New Zealand Herald or television, TV3 or anyone, every public or private media, could be held to account in their form of expression, both through those organisations and through suit. And yet internet service providers that have got a route round can rob their revenue and have no responsibility for not being for being less responsible than them. So I just wonder whether the government where the government ought not to be taking on the regulatory burden here, should be enabling the courts. But maybe there's a case for safe harbours like that, and maybe there are more.
Yeah, I think I want to move on to a slightly different subject. Stephen, you get one more question, all right? So, I want you to really make it a good one. And Jordan, the same goes for you too, all right? Because I have to let other people answer questions. But I just want to move on a little bit. We could talk about it for length. And I really want to talk about my hatred of the Law Society Standards Committee at some point. But I think, a really important thing is that we all have our blind spots on freedom of speech, right? And, I would say this is definitely a sort of right-leaning audience today, and that's because at the moment, most people who feel aggrieved about censorship are people on the right. That's me. Like when Jonathan Ayling said that, about the Pope and Galileo, I was like, what the hell? The Pope was right. That was definitely justified censorship. What are you talking about? Just public interest and stopping the, heresy from getting out. But we just have a law that's just got onto the books, of course, which is the banning of gang patches. And it's interesting for me to talk to other free speech advocates or enthusiasts who will all of a sudden start to make an exception for that because, intimidation doesn't count, and we need, and all of a sudden you start to see these justified limitations start to get sort of brought up. David, you were the Shadow Attorney General when the law passed, and David too, you would have to apply that law. I was just wondering, could you just maybe speak to it a little bit? Do you think it's an example of good lawmaking? Is it the type of law that actually can be practically enforced? And we know that the Attorney General of our own government thought it was an unjustified limitation under the Bill of Rights Act, but governments pass laws inconsistent with it all the time. You yourself, your government might have passed a few.
Actually, not often. Yeah. Not often.
Yeah. Well, could you maybe talk to it about whether or not you think are you committed to repealing that law? Do you think it really is a problem? And do you think it's going to work as a law?
We haven't committed to repealing it. We haven't taken a position on that yet. I was visiting someone in Devonport just before I came here and was driving back down Lake Road, and about 20 or 30 killer bees came past on their bikes. Most of them had some form of killer bees on their backs. I think everyone, including me, felt, how you feel a bit nervous and intimidated. And I, not long after a police car pulled out and started following them, and I thought to myself, what happens if that police car stops and these people crowd around and do bad things? Would I be brave enough to stop and help out? All those thoughts went through my mind. I don't know what the answer is, by the way. And I hope I never have to find out. I abhor violence, illegal violence, and intimidation, and I think I find it hard to disassociate the patch with. I find this freedom of expression argument quite hard on this one, because I don't mind people, walking around with a, I don't like it, but I think If someone wants to wear a swastika, it's wrong, but it's legal. And I ask myself, what's the difference between that and a gang patch? But we do have a problem with gangs in New Zealand, and I'm actually willing just to wait and see here a bit, even though I accept the purity of your freedom of speech argument. So that's a you purists here, you'll say, what a turncoat.
But the unprincipled ones really like you. Yeah, it's like 50-50.
It's a hard one for me.
Well, okay. You asked would I enforce it. The simple answer to that is no, because I don't have to anymore. If I still had a warrant, yes, I would have to, because my judicial oath would require it.
Well, if you're on the Court of Appeal or the Supreme Court, then you could just read it down so it doesn't.
Oh, I'm sure I could find some. I'm sure I could find some tikanga argument to get around it. But I was having dinner. Do we have Chatham House rules here? No, it's a freedom of speech.
I'm sorry, it's too late.
Okay, I won't be able to tell.
Only
that.
going forward, all right. So everything that's been said already.
I can't tell that story. Okay, but the situation is this. From a freedom of expression point of view, the gang patch law is a bad thing. The reason for that is that, firstly, it is discriminatory. It discriminates against a certain group of society. Now, I've got a leather jacket at home, and it's got Mickey Mouse on the back of it. I got it at Disney World. It's one of my favourite pieces of winter clothing. Now, that's a gang patch, if you like. It's a Disney gang patch. So, fortunately, it doesn't fall within any of the categories of gangs that are listed in the legislation. But someday, some outfit could get into power that could say, we're going to add Disney to the list. And while we're there, we're going to add Lions and Rotary and the Free Speech Union, because I understand the Free Speech Union has a pretty good patch T-shirt as well, which I want one. But yeah, this is a sort of situation that you have with discriminatory type of legislation. Furthermore, it interferes with those people's freedom of expression. They want to get up and say who they are and what they're involved in. Now, on the bench 30 years, I know damn well what they're involved in, and I don't support it one little bit. But frankly, I would like to know who the hell they are, so that then I can keep an eye out for them and avoid them like hell. So that's my
Duncan
take
Webb,
on it.
our Justice spokesperson, agrees with you.
That's nice.
I find it a nuanced argument on this one, I've got to say.
Yeah.
Okay, so
And the winner goes to the principled free speech advocate. A Free Speech Union gang patch.
all right, so I want to go from gangs and Nazis to the New Zealand Law Society. I'm sorry. No, look, I really want to talk about the cricket match one. I really do, because so if you're not familiar, not aware of it, so it was all happened a couple of years ago. A couple of, like me, provincial commercial lawyers. That's why I'm so upset about it. Sending each other emails, organising a social cricket match, and they make some lame jokes. We'll have a cauliflower on the team to represent non-human, plant life, and we'll have a koala bears to make sure that non-human animal life is represented, and all the white men are going to have to apologise before the game. So it's just a private email between lawyers, not with the client, not on a file. Some officious person in someone's office sees it, anonymously complains to the Law Society. The Law Society refers it to the Standards Committee. After a great length of time, the Standard Committee decides they want to do an own motion investigation into it. There's an extensive inquiry into the joke. They decide not to proceed, but they don't tell the lawyers that for 11 months after they make the decision. And they make some parting shot in the thing saying, right, well, we're not going to take any action against you, but, you're in breach of your obligations, but it's at the lower end. But we're not going to give you a chance to submit, to have your say about that. And by the way, you can't publish this anywhere or tell anyone that we've done this. Law Society, the lawyers eventually went to the Court of Appeal, and the Court of Appeal said, what the hell? Of course they have to be allowed to talk about it, And so, again, we're just talking about the meat grinder of the process, right? Because that's those two guys, the most sacred people on this earth, commercial lawyers from the provinces. They make the pillar of their communities. Because of something, a joke that they made, having to have that stress on of losing their livelihood for all that not losing their livelihood, but professional embarrassment and real consequences for all that time. And we see this all the time now. We talk about the universities. We had a lot of that talking today. So we have these informal disciplinary processes, formal, informal. We have these extrajudicial processes, and officious people can make a complaint very, very easily that will chew up your time, your resources, and there's no consequence for bringing the complaint. There's no consequence for investigating an unmeritorious complaint or a complaint for a de minimis thing. All the consequences on one side, the party that was exonerated, right? And so how can we talk about losing trust in institutions, losing trust in the ability of the system to work, when all the risk and all the responsibility is loaded up on the side of someone who made a joke about putting a cauliflower on a cricket team. And I just wonder, have we gone too far in terms of requiring regulatory bodies to investigate all complaints? Do we need to have some sort of real consequences for regulatory agencies, oversight bodies who investigate things, who don't resolve them in a timely way, and who ultimately pay no price, apart from maybe being a little bit embarrassed around the office?
Well, there's two issues there for me. One is taking seriously things that are not too serious. I would say that the pendulum's already on the way back on that, actually. That's my opinion. As an observer of these things, and politicians, we've got a feel for these things. We survive by our instincts a little bit as well as analysis. So that in respect of the process issue, we've already talked about that. But I lament the rise of the administrative state, and it's not just caused by central government or local government. It's industry associations. It's you name it. Everything has become. Maybe it's partly a consequence of word processors. When you used to have to write
emails, definitely. It's
easy to cut and paste and create something that's a precedent or based on the other thing. Everything gets more and more complex. So, but I think that the societal trend has peaked, and I trust in the common sense of people, and I think that it'll get better.
David, can I just ask, if you were a judge today, would you be much more scared about telling off a junior counsel for, turning up late or not being prepared? Is that sort of idea, or would you be fearless and you would brave the allegations that you were bullying or being, or being unfair or discriminating by, requiring that, certain standards be
I got
met?
a couple of lawyers in this room who used to appear before me quite regularly. They know what the answer is.
Can I comment though that one of the problems is when the minutiae and the bile get so widespread and pretend scandal becomes so common, real scandal goes unnoticed. And I'll give you a real example of that from me. I had something happen, and I'm not going to give you too much detail here, but I had something happen in one of my ministries that I was responsible for, and it was terrible. It was wrong. And I was responsible for it. I wasn't the cause of it. I didn't even know it. So it wasn't my fault, but I was responsible for it. And, Stephen Franks and I were in Parliament at the same time. I've been around in Parliament now for more than 20 years. When I started in Parliament, that would have been a real scandal, and it would have been on the front page of the paper, and there would have been consequences for the government for the incompetence that I was responsible for in my department. And it was improper behaviour. It came out. I was prepared for it for 2 weeks. How am I going to manage this? Do you know, I didn't get one question from the media.
Can I build on that a little bit, Liam, in terms of the comments that you've made about the administrative state? Because we've got a woman, Janet Dixon, here today, who many people will be familiar, and I appreciate her case is currently before the High Court, but also submissions that have been made on the tikanga Māori question before the Regulatory Reviews Committee. The development of regulation and secondary legislation continues to become quite expansive and see either tests of religion effectively or just the imposition of ideological positions on individuals who then have no recourse for accountability. How do we hold these reins tight so it just doesn't become all-encompassing?
Through democracy.
It's
Not through autocracy.
the people's voice, Jonathan. I mean, the thing is, the people have spoken. In the United States, 72 million of them have. They've found their voice. They have expressed a point of view that has been of concern to the American population. For decades. They have been unhappy with the way in which America has been heading. They have expressed their point of view. Whether we like it or not is another matter entirely. But it is time, and this is a free speech issue, it is time for people to speak up and make their voices heard. That's democracy.
On a minor point to that, though, I would fault Parliament for the quality sometimes of the legislation that comes through in terms of not being precise, not having bright red lines. We have a real fashion in our lawmaking for having principles-based legislation where the rules aren't spelled out, but the principles are set out. We won't tell you how to live up to the rules or what the principles are, but if you get it wrong, we reserve the right to jump on your neck. And, we'll use prosecutorial discretion to make sure we only get the really bad people. And that is something that I have noticed more and more and more. We're moving away from rules-based law into principles-based law, which just admits of so much more vagueness. Vagueness is always going to require a conservative, risk-averse interpretation. It's just, a better quality legislation would be help. Now, there was a question down here, and I know you've been waiting, so do you want to go for it?
Yeah, I've got a question and a comment. My question is to David, and I'm David Parker. And I still call David Harvey Judge Harvey. And I'm a lawyer. I am from Iran. I studied in Iran for 4 years, did my bachelor degree there, and that half through my master's degree, I had to leave Iran because it was very political, against the government, and very blunt and outspoken. So you said, in response to Jonathan about tikanga becoming compulsory and the university...
I haven't made any comment about that today.
No. You just said it's all about democracy. You said it's all about democracy.
I haven't, no, if you're going to... I've been very clear, I've made no comment about it. I chair that committee.
I understand that.
I'm not making any comment on that.
And I'm not asking you to make any comment. I'm making comments on that. Okay.
What's the comment?
The comment is that the regulation committee is tasked with something incredibly important. And I'm talking as someone who's not a New Zealander, in a sense that I did not study in New Zealand. And when I came to New Zealand, I studied common law. I'm a master's graduate from Auckland University. Not once in the past 12 years, I had to use anything regarding tikanga. I know about tikanga. I know about how important it is to bring cultural past into your experience as a lawyer, but I was not forced into learn tikanga. And as an international student, if I know that I have to come back to a country to be forced into learning something which I'm not interested in, I would not come to this country. The same way that in Iran, they shoved down our throat learning criminal law, both in Farsi, which was relevant to what we were doing and what we were going to use, and Arabic as part of a very extremist Islamic law. And what happened to those people who disagreed with that, who didn't want to learn about it? They ended up hating it. They ended up leaving the country. I don't know why you want to stop me, Liam.
Well, it's a very good comment, and it is good to get the perspective of someone who's been through an oppressive regime, because the University of Auckland, isn't that fun for everybody.
No. Well, it was. In 2010, it was much better than a wokeism that we see these days. But my other comment was so I'm really, really hopeful that the regulation committee is going to make the right decision, because the comments you have received is far from democratic. You received comments from the Law Society, which we know how woke it is, which we know they have there's nothing of interest to them but to prosecute lawyers.
I'm not going to comment on the merits. I do know what the role of the Regs Relations Review Committee is, and I'll deal through that process there.
Yeah, I'm sure you will, but I'm reminding you that you're tasked with a very, very important decision. Okay, I'm not telling you what to do, what not to do. But
Right.
Liam, the other comment I had was about the Digital Harmful Communication Act that Jordan brought up and Stephen. I think there is a bit of a misunderstanding about the Digital Harmful Communication Act.
One more question.
And I haven't yet, I don't know about Judge Harvey, I haven't yet as a lawyer come across anybody being prosecuted for making harmful comments online under the Digital Harmful Communication Act. Usually, the reason you charge people is for posting harmful material, such as having sex with your girlfriend when you break up and then the video goes all over the internet, or as David said, posting something which is really harmful in terms of killing people and terrorizing people and then posting it. I haven't yet seen a case where people have been... That's why I asked Roderick if his client was actually communicated. Yes.
Yeah. We have time for one more question and 0 more comments. So, great. One last question. Gentleman, hang on, I'm doing a bad job coordinating. There's a gentleman standing up, but we'll have 2 questions if they're quick questions because they both stand up at the same time. So guy at the back, guy in the middle.
Yeah, what's the definition of significant emotional harm?
It's actually serious emotional distress. That's the definition. Yeah, serious emotional distress is what the statute says, and that depends. This is a lawyer's answer again. That depends on the circumstances. It takes into account a whole lot of factors like loss of sleep, loss of appetite, whether or not you've had to see a psychiatrist, whether or not you're suffering from some kind of medical psychosomatic issue or something of that nature. It's a combination of circumstances that are able to be brought forth, and it doesn't. There's authority on this point of view. It doesn't necessarily mean that you have to have expert opinion on it.
So it depends, and that'll be $3,000. That's the lawyer's answer.
You see, he's a conveyancer. He comes in cheap.
Yeah. Right, very last question.
Thank you. We've heard much today about the law and intricacies of the law. What we haven't heard is a relevant case study, and I'm pleased to say to the audience that in 9 days, I'm about to be one. I go before the Waitakere District Court to defend an HDCA application, and I've had to do it self-represented because, as Liam rightly said, law opinion costs money. The quote I had was $25,000 to $50,000 to defend myself. So I bought Dr. Harvey's book, which I'm in. Thank you. So I've worked my way through that, and in 9 days I presented a 700-page defence, 50-page affidavits, 83 exhibit notes, 4 digital exhibit notes, and given the current legal system, I should be able to come back to you when I'm retired in terms of the outcome. So there are real people at the end of these procedures. This is not theoretical.
That's not a question, but it's a really good point. And we are out of time, but the point is really, really well made, that we talk about the abstract, we talk about how we'd like things to work, but it's people that get thrown through the meat grinder of the legal system for years of their life. And they'll never be able to think about anything else on their weekends.
May I just finish on one point?
Well, yes, as long as it's like
It'll be
5
very short.
words.
David Parker asked a question of Judge Harvey. He said, are you allowed to defame me? My answer would be yes, on the basis there are natural consequences for doing so, which would be tested within the legal jurisdiction. Thank you.
Thank you very much.
All right. Thank you so much to our distinguished panel, Liam Heir, the chair, along with David Parker and David Harvey. A round of applause for them. Thank you very much for the last hour or so.